Hey there, I'm Neil's virtual assistant, Declan O'Luller. Just call me Bob. Welcome to this essential guide on vicarious liability within the Irish employment relationship. Vicarious liability is a legal doctrine where one person or entity is held responsible for the wrongful acts of another, even if they didn't personally commit the act. Traditionally, Irish law applied a restrictive in the course and scope of employment test, but this has evolved significantly. The modern approach, aligning with broader common law trends, focuses on a close connection test, expanding liability beyond traditional employment and rather examining the nature of the relationship in question. To establish vicarious liability, three key requirements must be met: a wrongful act, a close relationship between parties, and a meaningful connection between the act and that relationship. The wrongful act must be a recognized tort, such as negligence or assault, committed by an individual. Secondly, the individual who committed the act must be in an employment relationship or that resembles an employment relationship with the party being held liable. This involves examining factors like the employment contract, control, integration into the business, and how payment and tools are provided. These are very similar to the factors considered to distinguish between an employee and a self-employed person, a topic we will focus on next. Finally, the act must be meaningfully connected to that relationship, often referred to as the course of employment or, more broadly, the close connection test. The Supreme Court case of Hickey v. McGowan in 2017 solidified the close connection test in Irish law, extending it beyond traditional employment. This landmark case held the Marist Order of Brothers vicariously liable for sexual abuse by a member, demonstrating the test's application to unincorporated associations. The justifications for vicarious liability are rooted in policy decisions like fairness and risk management. Employers create and control the environment where risks may arise, making them best placed to prevent wrongful acts. They are also typically better positioned financially and organizationally to compensate victims, often through insurance. Furthermore, the doctrine encourages employers to implement robust risk control, supervise staff effectively, and establish clear safety procedures. However, vicarious liability is not without its limitations. The wrongful act must be a recognized tort, and the relationship must be genuinely employer-employee or akin to it, not an independent contractor. If an act is a frolic, wholly private and disconnected from employment duties, the employer is unlikely to be held liable. In a typical employer-employee setting, liability arises if an employee commits a wrongful act while performing or connected to their duties. This includes acts within the field of activities entrusted by the employer, especially where the employer directed, supervised, or provided tools. Consider a delivery driver who assaults a customer during a dispute over parking. If the assault occurred during delivery and was a mode of doing the job, however unlawful, the employer might be vicariously liable. However, if the driver assaulted someone on personal business after work, using the van, the employer would likely not be liable, as it's a frolic. The close connection test is fact-sensitive, examining how the employee's role enabled or increased the risk of wrongdoing, going beyond mere opportunity. Employers cannot simply avoid liability by claiming they didn't authorize the act. Authorization is not essential if the close connection test is met. In medical liability, hospitals can be vicariously liable for negligence by their staff, including doctors and nurses. For bullying and harassment, employers can be liable under the Employment Equality Acts, unless they prove reasonable steps were taken to prevent such acts. To minimize vicarious liability, employers should implement robust health and safety policies, conduct regular risk assessments, and provide comprehensive staff training. Examples like Lynch v. Binnacle Limited T. Iracavan Co-op Mart, 2011, IESC 8, and the decision of the Supreme Court in England of Mohammed v. W. M. Morrison Supermarkets plc, 2016, UKSC 11 highlight the broad application of these principles. Understanding vicarious liability is vital for fostering safer workplaces and ensuring justice in the Irish employment landscape. Thank you for joining in this quick look at vicarious liability. For further reading, please consult the cited sources.